about trademarks and GIs. Trademark registration is not compulsory, even though registration has certain advantages, such as filing cases for infringement. You can still bring a passing off action to enforce your rights in an unregistered trademark. Trademark registration can last indefinitely, subject to periodic renewals. Trademark law protects others from using marks which are identical, confusingly similar, or deceptively similar to an existing trademark. A trademark is registrable if it's distinctive for the goods and services you provide. You can use the R symbol with a registered trademark. Generic marks are weak and non-registrable. Descriptive marks are non-registrable unless they acquire a secondary meaning. Suggestive marks are weaker than arbitrary or fanciful marks but stronger than generic or descriptive marks. Arbitrary marks are strong and defendable. Fanciful marks are the strongest. The definition of trademark says that it must be capable of graphical representation. Let's have a look at different types of marks which can be graphically represented. Work marks, device marks, service marks, collective marks, certification marks, sound marks, smell marks, color marks, shape marks. Then there are well-known trademarks which receive protection even if they are not registered. The Indian Trademark Act also lists certain types of marks which are not registrable. Coming out of the world of trademarks, let's move on to GIs. A GI is a sign or mark which signifies that a product belongs to or originates in a particular region. However, products associated with a territory need not always carry the name of the place. Alfonso mangoes, Mysore sandal soap, Dharwad peda, the blue pottery of Jaipur, or the Pashmina of Kashmir are some examples of GIs in India. Registration is mandatory for a GI tag. GIs are owned as a collective private property or as a club asset. In India, an indication which signifies the geographical origin of agricultural private property or signifies the geographical origin of agricultural natural people. The registration initially lasts for 10 years and, just like trademarks, can be renewed indefinitely. Now that we are through the module, let's go to a recap of what we have learned. We learned that there exists different considerations for the protection of IP. One of them is territoriality. There is a misconception that once you get IP protection in one country, you get it globally. Well, we now know that this is not true. Territoriality is one of the basic principles of international IP law. It means that IP rights are only valid in the country where they were granted. We also learned that internationally, the Berne Convention, the Paris Convention, and the TRIPS Agreement recognize the principle of territoriality. This allows countries to form tailor-made domestic laws governing intellectual property. The above three international treaties also lay down the principle of national treatment for IP protection. It says that the member countries should provide the same advantages, rights and treatment for protection of intellectual property to citizens of other member countries as their own citizens. Next, we learned about the national character of intellectual property rights, which means the legislation of a country governs that intellectual property rights in that country. So, when applying for patent registration in India, the Indian patent law will apply to you and not the law of any other country, even if you are a citizen of another country. When seeking IP protection in other countries, you need to decide on the countries in which you want to file for protection. There are some crucial factors to be considered to make this decision, like countries where you propose to target selling your product or the country where you want to manufacture and the strength of IP protection laws in that country. The number of countries you wish to file for IP protection will also affect your decision to either file directly in the country or by filing a PCT application. Both alternatives have cost and other implications. Your interest and ability to monitor international markets for infringement of your rights and to take action against the infringement will also be a factor influencing your decision. We also learned that Other than national filing, there are different international filing procedures for different IP rights. For example, PCT and Paris Convention guide filing for patents and Madrid Protocol is followed for filing for trademarks. While there is no global registration system for copyrights, like in the case of patents or trademarks, but the Berne Convention provides for no formalities protection, and as soon as your work comes into existence, it will get automatic protection in all the member countries of the convention. For industrial designs, we have the option of filing the reciprocity application in India. That's all. Let's move on to the next lesson.
Sir, now you can proceed with your.
Yes.
And sir, Mr. Sumit Kapoor will be joined at 3:20.
Okay. I have lost the control. Can you hear me?
Yes, sir, you are audible.
Okay. Where's the control? Okay, got it. All right. Sorry for the initial glitch. Namaskar and good evening to all. I would like to welcome you all today for this L2 Pro workshop on a very interesting topic, protecting your brand globally, cross-border trademark registrations, and enforcement strategy for startups and MSMEs. I'm your host, Nitin Sharma. I work for Qualcomm as Technology Counsel, looking after various IP initiatives at Qualcomm India. I'm also co-chair of IPR committee at ASSOCHAM. This is the webinar series that we have started to connect with you all in the field of intellectual property. This is the century of intellectual property. For any country which aims to play a significant role in the global economy, intellectual property plays a very crucial role in achieving that goal. Through this webinar series and the L2 Pro platform, our goal is to spread awareness around IPR. Today's webinar is a very interesting one where we will hear insights on protecting the brands globally, cross-border trademark registrations, as well as enforcement strategies from multiple distinguished speakers. We'll introduce the speakers in a while. I'll take a moment to talk about L2 Pro platform. This series is brought to you by the IP course material called L2 Pro, which stands for Learn to Protect, Secure, and Maximize Your Innovation. Now, the whole idea of coming up with this platform started from our interactions with startups, when we realized that a lot of startups are very well versed with the concepts of intellectual property, and they have a good IP strategy built for their organization. However, there were some other organizations or startups which required handholding or more information around how to go about building an IP strategy. And this led to this concept, and we thought and then we partnered with DPIIT and CPAM, and of course with NLU Delhi, to create this course content that's made available free of cost to anyone who's interested in this topic. This also aligns with the Government of India, Startup India, and Make in India policies as it promotes the strong IP strategy for good, strong business, right? The picture here you see is the launch of this program with the DPIIT and CPAC. Now, this platform comes in two forms. We have.
Slide is not visible. So
Okay.
your PPT is not visible.
Reshare that. Okay. Can someone confirm if it's visible now? Okay.
Yes.
Great. Okay. So this platform comes in two modes. One is the website, so you can access it at www.l2proindia.com. This basically, as we said, like this platform aims to increase awareness and aid in better understanding of IP, how to protect your innovations with patents, how to maximize your value of the IP, how to use copyright to protect your software and other design documents, etc. How do you build a business around your trademarks, and so on and so forth, right? Basically, an endeavor to ensure that the intellectual property that's created by your organization is adequately protected, and you have a good strategy around building the IP, like creation of IP, managing it, as well as commercializing it. Okay, so this course has basically 3 levels, whether you access through website or an app. I think it has 3 levels. The first one covers the fundamentals of IP, covering details on patents, trademarks, geographical indication, copyrights, etc. So basically a full overview of what is an intellectual property, what are the types of intellectual property protection, etc. The next level, which is the intermediate level, talks about NDAs and other covenants around the agreements. It also talks about how you can secure your IP by filing an acquisition of different types of IP. How can you commercialize it, and how you can go and do a market assessment of where your IP stands, etc. Right. The next level is the advanced level, wherein we provide information around how you can access the venture capital funds based on your IP, and so on and so forth. We also have a module on standards organization, the standards and standard setting organizations, and how the standards process work. So in case if you are a technology company and if you are using certain standards, this information becomes very useful to you. Lastly, it also gives an overview around disputes management. How do you basically figure out an infringement? How do you ensure there is basically how do you take care of validity challenges, and what are the defenses, and what are the dispute resolution mechanisms like arbitration, etc. Mobile app is also very user friendly. There are some screenshots here that gives you some idea about how does it work. It gives you a good overview of the topic, followed by some quick questions to understand, to basically test your understanding of the topic, and basically allows you to navigate through the course. There are introductory videos. One of the videos you saw just before this session began. So we have an introductory video that introduces a topic, and then you have a quick quiz, as I said, to test your understanding. And once you go through the whole module, all the modules, you get basically a certification, which is co-signed by CPAM, DPIIT, NLU Delhi, and Qualcomm. So it's a pretty useful certificate, which kind of indicates that you have a basic understanding of all these concepts. All right, so with that, now we move to a very interesting segment wherein I would like to introduce our first distinguished speaker, Mr. Abhishek Chando. Mr. Abhishek is an intellectual property attorney with close to 8 years of experience, specializing in foreign trademark registrations and global brand protection. At SS Rana and Company, he leads the foreign trademark practice, advising clients on strategies to secure and enforce their brands across jurisdictions. He works extensively with both MNCs and early stage startups and MSMEs, helping them navigate the complexities of international trademark systems. He's got very deep understanding of the challenges that small and growing businesses face in expanding their brands globally, and he offers practical guidance on the cross-border registration, enforcement mechanisms, and risk mitigations. He's also helping businesses treat intellectual property not just as a legal formality, but as a critical tool for international growth and long-term brand value. It's an honor and privilege to have you, Mr. Abhishek. Over to you, and we are really excited to hear your thoughts on this very interesting topic.
Good afternoon, everyone. First and foremost, I would like to thank ASSOCHAM for organizing this impactful session. and for the opportunity given to me to speak on this very interesting topic. A special thanks also to Mr. Nitin Sharma for moderating and guiding us through the entire program.
Thank you.
I am Abhishek Chandok, a Managing Associate Advocate at SS Rana, and it's a pleasure to be here with all of you. As startups and MSME increasingly expand into international markets, the need to protect your brand globally becomes more than a legal formality for everyone. It's a core part of your growth strategy, but for many, navigating the cross-border trademark systems can seem a little complex and extensive. In the next 30 minutes, I will walk you through why the global IP protection matters, how to leverage the Madrid system for easier international trademark filings, the enforcement strategies, and the practical cost-conscious tips for startups and MSMEs. I will also try to look at real-world examples for you with some common mistakes and how Indian businesses are already using the Madrid system to their advantages. I will now share my screen. Can somebody confirm that the screen is visible?
Yes, sir.
Yeah, we can see it. Please.
Thank you. So the topic for today is protecting your brand globally, cross-border trademarks registration and enforcement strategy for startups and MSME. Most of us would be aware of what is a trademark, but let's just do a quick recap. Trademark is a legally recognized symbol. It could also be a word, phrase, a design, or a combination of all of these things, which basically identifies and distinguishes the source of our goods or services from those of other parties. Trademarks can be of various forms. It could be a word mark. Word mark is basically written in standard character forms, like how Zomato and Flipkart are written over here. Logos and symbols, examples are given over here. The logo for Apple or the Swiss design for Nike. These are considered as logo trademarks. Slogans or taglines, just like do it. Sound marks are different, like the Netflix intro sound or the Nokia connecting people sound. Many people would relate to that also. Colors and packaging shapes, for example, the blue color registered by Tiffany and the unique Coca-Cola bottle shape. These are all different types of trademarks which can be registered.
Sir, actually, Radha knows, Priyanka knows my mistake. I am not as first member.
Hello? Are we good to go? Am I audible?
Yes, sir. You're
Yes,
audible.
sir. Please continue.
Trademarks are territorial in nature. In the earlier PPT, we also saw that a trademark registered in India does not protect your trademark in the foreign markets, such as any market like US, Europe. If you want protection in different markets, you need to file an application in those specific markets. The initial protection is for 10 years in most of the countries. Most of the countries follow this rule that a trademark would be registered for 10 years, unlike Bangladesh or Nepal. Over there, the trademarks are initially registered for 7 years. But yes, 10 years is constant throughout most of the countries. And it can be renewed indefinitely as long as we pay the fees as the applicant. Now, why it matters, why a trademark matters? Because it protects our identity from misuse or imitation by any third party. It adds to my legal leverage as an applicant to stop counterfeits. It boosts my business value. IP is often factored into valuation during fundraising or merger and acquisition. And trademark is very essential for e-commerce and exports platforms. For example, Amazon brand registry. Over here are a few benefits of IP protection in foreign markets. It enhances the market value of your business. It turns ideas into profit-making assets. It markets your business products and services. Access or raise finance for your business. enhance export opportunities for your business. Now, I would come to few MSME and startup friendly IP tips. The government of India has launched the SIPP scheme, the Startup India and IP India schemes. Under this scheme, the government offers almost a 50% rebate for startups and MSME on their trademark filing. This is, right now I'm talking about India. The government offers a 50% rebate on trademark filing fees and access to IP facilitators who help with filing and process support at no or minimal cost. So anyone who is an IP facilitator can do a trademark filing at no professional fees. Only the rebated government fees has to be paid. The government also offers fast-track examination for quicker registration. The Indian government has online accessible public search tools, and you can easily access all the statuses, documents, and renewal portals just by logging over there. Now, when should we register is the question. Many of us think that delaying the registration, that we will do it later when we grow. Now, this is very risky because we might be sitting, but someone else may register a similar or an identical mark before us in our countries of interest. And fighting them off in an opposition or litigation suit is a very costly affair than filing an application. You also lose the chance to oppose conflicting marks. So it is very important that as soon as you have a brand, registration is filing and registration is very important. Trademarks should not just be considered as legal tools. They are strategic business assets. Don't treat them as a legal formality. They enhance the value of the company. They help in franchise expansion and export growth. Trademarks can also be used to build investor trust and unlock brand registry access on platforms like Amazon Brand Registry, because they need verified trademarks. That is the key for e-commerce visibility and protection. Now that we have a trademark in India, how do we go out? How do we file the application outside? So there are technically two ways, but I have written down three. The first one is the Madrid Protocol, which is through WIPO, World Intellectual Property Organization. It is filed once. It gives you protection in almost 130 countries. Good for startups. I will come down to the nitty-gritties of WIPO, the Madrid Protocol, after this. The second one is national filing. National filing is done how you do it in India. Like when we file the application directly with the IP office, it is similar that we file a national application in countries of our business interest. And there are few treaties like which offers regional filing. Like if somebody files an application under EU IPO, that gives you protection in almost all 27 member states of the European Union. Whenever you're planning to export, choose the right filing route for yourself. Madrid Protocol is filed once, very cost effective, but not all the countries are covered. Countries who are not signatory to Madrid are not covered. So for them, you need to file a national trademark application only. National filing is very tailored, very specific, but yes, it has a cost, a higher cost associated to it. Regional filing, it gives you a broad access. Like if we file in Europe, we get protection in all 27 countries, but it does not cover any other country apart from Europe. I think I've already covered this, that national filing is that you file applications in different countries. Separate application forms as per local practices. Applications would be filed in different languages. Payment is to be made to different lawyers in each country. Different currencies you have to pay out. And if you want to check the status of any application, you need to check the status from different lawyers or from different websites. And the time frames for registration also varies in national filing. Regional filings have covered the European trademarks. This provides protection across all member states. Benelux is a very small regional filing which provides access for Belgium, Netherlands, and Luxembourg. OAPI and ARIPO are two treaties which provide trademark protection in several West African countries and a different set of African nations. So if somebody is looking to particularly go for African OAPI or like African jurisdictions, then they can consider this. Now moving to what Madrid Protocol is, the crux of today's topic. It is administered by WIPO, World Intellectual Property Organization. It is a convenient and a very cost-effective system that offers the trademark owner the possibility to protect its trademark in several countries by filing just one application and submitting one single set of fees. Merit protocol, there is just one procedure. Why it is convenient is that you just need to fill in one form. File it in only one language, English. You have to only pay one set of fees in Swiss francs to WIPO. Only one currency, that is Swiss francs, and there is just one registration number which would be designated into other countries of your business interest. And also, if you want to later on file a renewal or any amendment for change of address or change of name, that can just be done through one request. So for example, if somebody has a trademark filed in 10 different jurisdictions through a national phase versus 10 different jurisdictions under the Madrid umbrella, for that renewal, 10 different requests will have to be filed. But under Madrid, you can just file one request for renewal as well, and the effect would be in all those 10 countries which you have chosen initially. These are few of the recent accessions to Madrid Protocol. India joined the Madrid with effect from July 8, 2013, and Qatar being the latest one to be added to this treaty. Now, how a Madrid application is filed? Madrid application and international trademark application, these are two similar things. How do we file it? There are three ways how we can file it. The first one is the IP India online filing system. Your application is sent through your office of origin. We are based in India, so our office of origin would be Indian IP office. We can also complete our application through Madrid applicant assistant and send it to our office of origin for certification. The third provision, which has newly been launched by Madrid, is the Madrid e-filing, but that is not available in India as of now. So the most convenient way to file the Madrid protocol application would be the IP India office online filing service. Now, who can file? Anybody who is a national of a contracting party. Contracting parties are basically who are signatories to Madrid protocol. Anybody who is a national, who is a domicile, or whoever has a real or effective business place establishment in any of the contracting parties. Who can file? There is a small basic requirement to file the Madrid application. The applicant needs to have a basic registration or application in their home country, or they have to be like a national domicile or real effective business establishment. A basic registration in your home country is a must for filing, because that basic application would be the basis of your Madrid application. Two types of Madrid applications are filed. When we initially file an application, that is considered to be a new application. A new application is to be based upon our home country registration or application, which in our case would be the Indian trademark application of ours. And it can be filed designating countries of our interest and paying their respective fees. I would come to the fee part later on. The second type of application, now let's suppose that initially we have filed the application in 10 countries. And after 2 years, a holder of the international registration wants to file that same application in 5 more countries. So they need not file a new application for those 5 countries. Those 5 countries can be added to your existing / initial international application. So Madrid Protocol allows you to add more countries by way of filing a request for subsequent designation. Said that every country has its own fees associated with it. Now, how do we calculate the fees when we have to go internationally? So this is the link, and this you can just type Madrid fee calculator on Google. You can just access this link. When the first column would be select the type of transaction as a new application. Our office of origin would be India. Just choose the number of classes which is covered by our basic mark, the Indian application. Select the countries of interest and calculate. That page will give you a breakdown of whatever the official fees is to be paid to WIPO in CHF. While filing the application, we just need to pay the entire fees to WIPO, and WIPO will administer and pay respective IP offices. One very important point to note is that the WIPO basic fees, WIPO also charges a basic fees when you file the application with them, and that remains constant when filing the application. It is 653 Swiss francs for a mark in black and white. That is approximately around 70,000 INR. This would be irrespective the number of countries. So if anybody is looking forward to file the application in 2 countries, the basic fees would still remain 70,000. And if they want to file in 20 countries, the WIPO basic fees would remain 70,000 in that case also. That is consistent throughout. And if the mark, the Indian mark, is in color, then the constant fees would be 903. And while adding more countries, which when we talked about was subsequent designation, it would also remain constant to CHF 300, approximately around 33,000 INR. But yes, this is the official fees which has to be paid to WIPO. Now, how does the process work of when we file an international application? As we discussed previously, that our basic application or registration, that is our basis for filing the application. We need to have an application in India. On the basis of that, we send an international application to our office of origin, which would be the Indian IP office. The Indian IP office examines our application. The timeline for that is somewhere around 1 month. If they find any objections, they notify us. If they don't, they certify our application and then they forward it to WIPO. WIPO, after receiving your application, it also does a formal examination as per their standards. At that point of time, if they find any irregularity, a notice would be issued for specification of goods. If specification of goods are not in compliance as per their norms, they would give you an intimation at that point of time. If everything is clean, then they would register the mark and publish it in the international registration. They would issue a certificate, but then that would be the certificate issued by WIPO. That does not mean that your mark has been registered in all the countries as of now. Once the certificate has been issued by WIPO, it then forwards your application to the countries of your interest, the countries which we chose at the time of filing of the application. Your application is then sent to all the offices, all different offices. When they receive your application, the IP offices after that examines each application separately as per their norms. It could also be that, for example, that we have filed an application in Australia and the second one is in Canada. Your mark is objected or is refused by the IP office of Australia. That does not mean that your mark cannot be accepted by the IP office of Canada. Each IP office would conduct different examinations. So refusal in one country does not mean that your mark is refused in all other countries also. But there are few challenges when we file the international application. The first one is dependency. For the first 5 years, our international registration, let's suppose that we have filed an application with Madrid Protocol. It depends upon, for the first 5 years, it depends upon our basic Indian mark. If our basic Indian mark is cancelled, rejected, or withdrawn within those first 5 years, then the international application is also lapsed. That is also lapsed. Meaning that whatever protection we have, that will also lapse if we have our registration done within those 5 years. But yes, there are discussions ongoing at WIPO to either reduce or remove this dependency period. There are still talks ongoing. It has not been finalized yet. Now, what happens if your trademark, your international application has lapsed? If it is cancelled during this dependency period, there is a provision to transform it into national applications in the countries which you chose earlier. The designated countries, if for example you chose those 10 countries, your application has lapsed, you will be given an option to transform your Madrid application into national application. And you would be given the original filing date, which is beneficial. But few countries currently do not have any mechanism for transformation. And independence after 5 years, your IR, within 5 years, we are dependent upon our basic Indian mark. But after 5 years, our international registration becomes independent of the basic mark. And changes to the basic mark no longer affects the international registration. Now, WIPO also gives you access to many different tools. One of them is the Madrid Monitor. That can be used for searching of trademarks, look up for existing international trademarks by name, owner, registration number. So there are different permutations and combinations which you can use to see what people have filed. Or you can also check the status of one trademark in any number of jurisdictions, whatever they have designated. I will quickly go through these enforcement strategies. Now, whenever you are launching, before launch, a search is very, that is the essence, that is very mandatory before you launch anything. Always conduct a search. There are online tools such as IP India or WIPO Global Brand Database. Or you can also get in touch with any trademark agent to have a search done and seek their opinion. Always register your domain names and protect your social media handles. You can also subscribe to watch services. Watch services are basically, for example, your trademark is Zomato. You can subscribe to a watch service for Zomato that will intimate you if anyone files for any identical or similar mark in any of the countries. Watch services can be tailor-made. You can subscribe it to any number of countries. You can also limit it down. So anybody who files anything similar to your trademark, you will be notified at that point of time so that you can take timely action. But what do you do once your trademark has been infringed? You can send a cease and desist letter. You can take actions through customs or online platforms such as Amazon to remove the infringing listings. Or litigation would be the last resort. You can seek injunctions or damages. Or you can also have the seizure of counterfeit goods under the trademark law. These are the statistics of how many applications have been filed as Madrid Protocol applications from India. This is the data which has been published on WIPO till 2023. India got accession to WIPO in 2013. So till 2023, we can see that there was a dip in 2020. That was because of the COVID era. But yes, after that, many startups, many individual business owners, they are again filing, and the numbers are definitely going to increase. These are top 20 designations. Designations are, I would just clarify once again, designations are countries wherein when an applicant is using the Madrid Protocol, which country are they selecting the most? Over here, India stands at number 10th. I would share some real life examples that what challenges or limitations are faced when using Medit protocol. So our application of the international registration, that is based upon our Indian application. Everything has to be identical. The name of the applicant, the address, trademark, class, and goods. Goods can be limited. They cannot be broad. You cannot add more goods, but yes, they can be limited because India accepts broad classification of goods, unlike other countries such as USA, Australia, or Canada. These IP offices request for specific goods. The terminology is different. And also the US PTO IP office, they ask you for specific goods, only those for which you would be dealing with. So there is this one example, charitable foundation services. This is accepted in India. Now, this is a very broad service. And this is a real life example I'm telling you. When we filed this through Madrid designating US, the US IP office asked and raised an objection. They wanted us to specify what is to be done. So in India, when your goods services are these, if you file these in US, they would be objected, resulting into delay of your application and also professional fees of the lawyer who would be filing the response. So when filing the application, you should always check your goods, whether they are in compliance with the countries which you are choosing. Because few countries require very specific goods. There is a tool which is available online, Madrid Goods and Services. You can check the goods from there, or you can also seek assistance from any trademark attorney. This is also one example, like this good investment advisory is accepted in India, but when you file it through Madrid, it asks you to amend it to capital investment advisory services. These are all, see, this can be done at a later stage also, but that will just delay your registration process. So rather do it in the beginning when you are filing. If somebody wants to check the goods, they can just simply type Madrid Goods and Services Manager, and this is a very easy website. You can just type the name of the good and they will tell you whether they are accepted or not. One more challenge which is now being faced is that email address is required in few countries such as USA. USA recently had a change that they require email address of the applicant in all the applications. This change was recently notified. But for applications which have been filed previously, or whenever we file through the Madrid route, the email ID is given, but then possibly that is not transmitted to the USPTO IP office, which results into an office action. So these are also talks which are ongoing with the IP India and at USPTO, so that they can take that information of email ID from the office of origin so that it does not delay the registration process. Why do you think that trademark protection in foreign markets is important for your business? It gives you expansion into new markets. It builds brand recognition and your trust globally. It protects against infringement and copycats in their countries. It avoids disputes and legal complication. These are few examples of trademarks registered by Indian companies using the Madrid Protocol. Vadham for class 30 is for teas. And these are the designations. It has a very long list, but this is just a screenshot. Fixed Derma for cosmetics. This is also again a very long list. IPR, International Trademark, mentions that this is a Madrid filing. FDC, they are into pharmaceuticals and medicinal preparations. They have also filed using this Madrid protocol. Now, few of the common IP mistakes which are made by us as exporters. We believe that IP protection and laws are universal, but now that we know that they are not universal, they are territorial in nature, and we need to file separate applications in each country, or we either need to use the Madrid protocol. We often disclose information without confidentiality or a non-disclosure agreement. Exporting licensed products without authorization of licensors. So one very big mistake which we have come across, which is done by us, by the business owners, is that they are selling into foreign markets. They have not entered into an agreement with the distributor. So what the distributors do, they take advantage of that and they file the trademark in their own name rather than the trademark in the name of the Indian company. And after that, they ask for a very hefty price when they have to transfer it. And if your distributor gets registration in their name, they can stop you from using your mark in that country. So it is very important to have an agreement done with them. Examples of Indian brands being infringed in export markets. As we all know that Tanishq is a very renowned jeweler, and a third party has filed for a trademark Tanishq for jewelry in Switzerland. This was filed in Switzerland, filed on 2015. On the next page, there is again one more example of Alan Solly being infringed in Mexico by any third party for clothing and apparel, which is the same business. Also, when you are about to export to different markets, always check for nuances or translations of if your mark has any other meaning in any different language, because that can bar your trademark from getting registered. These are few of the examples which could not make it. Like for when Mitsubishi introduced their car Pajero in Spanish market, it had to change its name to Montero because Pajero is a slang in Spanish. Bing search engine, Bing means illness in Chinese, so it could not get registered. Now I thank you all for patiently listening, and I'm now looking forward from Mr. Sumit Kapoor of Amazon right after this, who will share his valuable perspectives from the industry side of brand protection.
Thank you. Thank you, Abhishek. It was a very insightful session. And
Thank you.
So our second distinguished speaker is Mr. Sumit Kapoor. Currently, he serves as a customer trust external relation manager at Amazon, leading leading strategic engagements with industry stakeholders on critical issues, including product safety, fraud prevention, cybersecurity, brand protection, and anti-counterfeiting initiatives across the APAC region. He closely collaborates with brands, industry associations, and enforcement agencies to strengthen Amazon's customer trust framework and safety features. Previously spearheaded the enforcement division of CPAM, Ministry of Commerce and Industry, Government of India, where he successfully developed and implemented IP rights enforcement policies. His expertise is backed by an LLM in intellectual property law, jointly awarded by University of Turin, Italy, and the Whiteboard Academy. It's an honor and privilege to have you, Sumit. Over to you, and look forward to your insights on this great topic.
Perfect. Well, thank you very much, Nathan and SHM for the kind invite. I hope I am audible.
Yes.
Parul, can I request you if you can put the presentation on the presentation mode, like the full screen mode? So that
Sure, sir. I will do that.
it is right next to that zoom in, zoom out button. If you click on that, the presentation will go into the presentation mode, the full screen mode. But in the meantime, Parul does that. Abhishek covered in detail about the trademark ecosystem, the global ecosystem, and he made my job, a bit easy. What I'm gonna do is I'm gonna focus on, what Amazon is doing for, brand protection and protecting customer trust. but the presentation is, what I intend to ask you is to look at this presentation. Thank you. From a general perspective, because these principles that we applies to Amazon may more or less apply in sort of in this industry, in this ecosystem. So while I'm going to talk about the work that we are doing at Amazon to protect customer trust, this should give you a sort of a decent understanding of how you need to protect your brand when it comes to digital marketplaces and especially e-commerce. With that, next slide, please. At e-commerce and at Amazon, everything is customer centric. We have a customer centric culture, and it is a critical part of what we do. Earning and maintaining the customer trust is the focal point of our work. Customers expect that when they purchase an item on our store, sold either by Amazon or by any of the third-party selling partner, they expect that they will receive exactly what they ordered. Now, this is why we focus on creating a trusted shopping experience and keeping brands and customers safe from sort of fraud and abuse. Our strategy when it comes to brand protection is focused on 4 broad pillars. The first one is the proactive controls. The second one is having powerful tools to protect brands. The third one is, of course, accountability for bad actors and customer education and support. Now, I'm going to take you through all these 4 pillars, and we're going to talk about them briefly, but sort of, we want to touch based on all these pillars so that you have a decent understanding of how, what encompasses in all these 4 pillars differently. So next slide, please. So talking about the first pillar, which is the robust proactive control. Next slide, please. The first step of the proactive strategy is to do a comprehensive seller vetting. We vet all of the sellers who try to start their business on Amazon, and we verify potential sellers' identity by using a combination of sort of advanced machine learning technology and also the expert human review. Now, each and every potential seller on Amazon has to go through this vetting process. They must provide either a government issued photo ID or some information about their identity, their physical location, the taxpayer information, their sort of financial information like bank account, credit card, so on and so forth. Now, our proprietary systems would analyze these hundreds of unique data points to verify this information and detect any kind of potential risk. And at last, we would add, say, on a case-to-case basis, in-person verifications that would require prospective sellers to have, say, one-on-one conversation with one of our team members to verify their identity and documentation. Well, this high-tech experience also allow us to help honest entrepreneurs and sort of small and medium scale businesses that are trying to sell at Amazon stores while making it more difficult for the fraudsters who are trying to hide. And thanks to this comprehensive vetting process, like we have stopped over sort of 800,000 attempts to create new selling account, preventing these bad actors from publishing even a single product for sale. Next slide, please. Now, in addition to the comprehensive seller vetting processes which are in place, we are also constantly monitoring our store for any potential infringement. Now, our automated technology has scaled throughout, and we have analyzed every potential new listing before it is published onto the platform. So it's basically, the proactive part is basically a mix of both are coming on board, and the bad actors are sort of deemed. Hello, am I audible?
Yes, sir.
Okay,
Please
sorry,
go
there
ahead.
was some tech issue and I dropped, but I hope I'm sort of audible to the
Yes, sir. Yes.
attendees. Perfect. So we were talking about the the proactive processes that are in place, and I spoke about the proactive processes, basically a mix of two broad things. First one is the verification process, robust verification process, and the second one is using technology to automatically detect and prevent bad listings from getting onto the store. With that, let's move on to the next slide, which will talk about the powerful tools that brand owners can use to protect themselves and their customers. So this is our second brand protection pillar. And we know that brand knows their product the best. And so we provide them with the tools that can protect them and empower them to say identify and remove any kind of bad listings or counterfeit listings. There are multiple tools like brand registry, which Abhishek also mentioned in his last presentation, transparency, Project Zero, etc., which can be used to tackle with these bad listings. I'm going to talk about these tools now. So next slide, please. So the first umbrella tool that is in place is called brand registry. Perhaps brand registry is the entry point for you to start building and protecting your brand on Amazon. Now, we created this tool in year 2017 to capture some accurate and actionable IP information about the brands. And since then, over 700,000 brands have enrolled in brand registry worldwide with either a pending or a fully registered trademark. Now, brand registry is also the foundation of the continuous monitoring that I spoke about in my proactive part of the presentation. So once you enroll your brand in brand registry and share information about your intellectual property, the automated protections are immediately activated. And let's talk more about some of these tools and the features which are available within the brand registry to help you sort of protect your brand. The next slide, please. The first one is a very simple tool which is called Report a Violation. And as the name suggests, this tool is basically to help you report infringing listing to us. So, the idea was to streamline the process where if you come across any infringement, you have the capability to report it to us so that we can review it and take an appropriate action on that listing. Now, over the time, we have made this tool very comprehensive. We have introduced new features and updates as we hear from the feedback on this tool. But broadly speaking, this tool helps you to do the global search of any kind of infringement on your brand, and then help you to report any kind of infringement back to us. Now, in addition to this, it helps you review your submission history. The tool is basically it is comprehensive enough to uh, tackle all kind of IP infringement at one place, or majorly all kind of IP infringement at one place. So if you are dealing with a trademark infringement or a copyright infringement, patent infringement, or a design infringement, etc., you can report all of them at one place. Now, there are multiple features available, like, for example, you can search using image, or you can search maybe using the keywords, or you can do a bulk search. You can do bulk reporting. So, for example, if you found, say, 100 infringing listings, you do not have to report them like each listing separately and do it 100 times. You can instead club all those 100 listings and report it in one complaint. And then, as I said, like, it gives you an access to the submission history, which basically let you see what you have reported and what action has been taken on that report within the last 6 months. It's basically a very comprehensive tool, very widely used tool by the community to help protect their brand and report any kind of infringement to us. Next slide, please. The next tool is Project Zero. It is, again, a very interesting tool. The Project Zero, as the name suggests, like when we started this tool, the idea was to help bring counterfeits to zero, right? And hence this tool was called as Project Zero. Now, Project Zero is an advanced variant of report a violation. In this tool, instead of you reporting an infringement to us, the power is in your hand to take down a listing. So if you have access to Project Zero, it gives you unprecedented level of responsibility. But we felt that this could really help us and also brands to work more closely and effectively together to bring counterfeits to zero. So practically what it does is, if you see that, look, there is an infringement happening on your brand and you have access to Project Zero, you can go and take down those listings on the real-time basis, and the listing would be gone. We definitely have some checks and balances in place. We do the audits of these takedowns at the back end, and then also there is a process to get access to Project Zero. So you need to, because and the lawyers in the room would appreciate, there are legal repercussions when you take down any listing. So we want to ensure that, look, you have good enough information to use the tool. So you need to maintain a very good score. You also need to undergo a small training process, so on and so forth. So there are checks and balances in place to ensure that the tool is not being misused. All right, let's move to the next tool. Next slide, please. Yes, this tool is called Transparent. And this tool is, again, a very interesting tool, which is basically like a serialization tool. And I'll be very quick on this one. So this basically allows you to have certain codes which are printed onto your product. And every time your product enters into our fulfillment center, that store is being scanned. And whenever it leaves the fulfillment center, again, the code is scanned. This tool basically ensures that there is sort of whatever is getting into the fulfillment center is an authentic product because it is coming directly from the brand, and when it's going out and the customer receives it, it's an authentic product. It's the same product that came in, and we're doing it using this serialization code technology. There are multiple aspects how we are using it, how customers are using it. Like one of the feature in this tool is customer facing, where a customer can scan the code and ensure like he or she can not only read about, get to know about like whether this product is authentic or not, but also they get to access like multiple information which brands may choose to put, like say how to use this product, right? There could be videos on like, hey, how to assemble, disassemble, um, sharing technical know-how, or if the product has got any expiry, so what the expiry looks like. So I mean that the experience, the customer facing experience can be customized to a great extent as per the needs of the brand. So this is again a fantastic tool, which is one helping ensure that the brand is being protected, but at the same time it is helping the customers to know that product better. All right, next slide, please. Yeah, so this is how transparency works. I already spoke about it. So you can select the product you would like to enroll and then apply transparency codes to it. The transparency codes are scanned whenever the product comes in and goes out, and then the customer can scan to authenticate the units, and it can sort of reveal any data or video or any kind of promotional material. Next slide, please. Okay, we can skip the next slide. We can move to the next slide, please, given we are sort of short on time. Okay, this is one of the tools that I wanted to speak about with this audience. So this tool is called IP Accelerator tool. Like Abhishek mentioned about the importance of having an intellectual property. This tool basically allows you to sort of get an IP, and especially trademark in this case. Now, what we realized was that for a business owner, and especially startups and sort of medium scale MSMEs, they tend to focus more on their business rather than the complexities of, say, getting a trademark registered or the sort of legalities of IP, which at times can be slightly complex, right? So we thought, like, what could be an app solution for this? And this is one of the tools that helps to sort of bridge between. So it helps you basically obtain an IP, and how we do that is we try to we have a sort of set of empaneled law firms who we have a standard agreement with, and there are sort of predetermined conditions and sort of negotiable prices on which they will provide their IP services under this program. Now we act as a bridge where we help these startups and MSMEs to connect with these law firms as per the standard contract, as per sort of pre-negotiated rates and terms and conditions. Now this makes the entire process a lot more easier for startups and sort of MSMEs who tend to focus not too much on the sort of procedural side of things, and rather focus on growing their business, which of course is one of the primary tasks that they signed up for. Now, so this tool has been pretty helpful for this community to obtain those sort of IP in a much easier, streamlined manner. Okay, so let's move on to the next section, which is talking about accountability for bad actors. We can skip this slide and move to the next one. As like by now how seriously we take about brand protection and dealing with counterfeits. One of the key issue was like, how do we deal with these counterfeits in the offline space? Of course, we are taking some actions on the online space on our stores, but ultimately the bad actors are up there. They're sort of, they need to be brought to justice for the wrong that they are doing or have been have been done by them. So we created this unit called Counterfeits Crime Unit, which is like a global team that would work with brands, law firms, enforcement agencies, and customers across the globe to go after these bad actors who are trying to misuse the store and infringing on your mark and bring them to justice in the offline space. So this is a team which is built up of, say, federal agents, law enforcement agents, people from FBI, risk managers, so on and so forth, who are working rigorously to deal with this issue. We'll quickly move on to the customer education bit in next slide, and we can move to the next slide. And one of the important component of what we do is the customer education and A to Z guarantee, which is part of Amazon Trust. We want to ensure that if something goes wrong, customer can be confident that they will always be taken care of. And for decades, we have A to Z guarantee that ensures that customers can get a full refund for any item they purchase, or if the item turns out to be damaged or say defective or materially say different from what they have ordered, so on and so forth. And this guarantee extends to issues like counterfeit as well. Well, with that, let me thank you again for being patient and sort of listening me through. I will be available, but I have a hard stop at 4:30. So if there are any questions, I'm happy to take them now.
Okay. Thank you again. This was very insightful session, Sumit. Thanks again. Looking at the comments, I think people are really interested to know a bit more on that. So let me take a first question from the chat box.
Okay.
Yeah.
Can I see
All
the
right.
chat box?
So basically, I think let's see. The first question would be: I have started MSME startup in March 2025, and I want IP protection. Please suggest. So okay, so I guess we may need a little bit more context to it. Mr. Soni Gupta, you may have to give us a bit more details on what exactly you're looking for. So let's move on to the next one. 50% in government fees, but professionals take full fees, right? That's in the context of maybe Vishek, your presentation.
Okay, I would take that up. Yes, there is a rebate of 50% for startups and MSME, but yes, different law firms or different professionals, they have a different set of fees. So like they would be charging you as per their caliber. But yes, if someone is an IP facilitator, they would do it at no cost. Like we at SS Rana, we help startups file their IP at no cost because we are IP facilitator. So if you're going through an IP facilitator, there would be no fees, no professional fees. Official fees would be 50%, no professional fees.
Great. That's wonderful. Thank you. The next question is prior registration in country mandatory for Mandate?
So prior registration is mandatory or not? You need to have a basic application. You can file your Mandate application on the basis of your Indian application, but you need to ensure that your Indian registration gets matured within the next 5 years. It should not get lapsed within the next 5 years. You can file on the basis of application, but it needs to be a registration within 5 years. It is advisable for all those who are planning that when to file, whenever your application in India surpasses the opposition period, because that is the last stage of receiving any objection any last minute tricks, opposition. Once you are done with the opposition period, file your application at that point of time, because that is the most safest option, that yes, you are not going to get objected by anyone.
Okay, thank you. Okay, what is the filing fees through Madrid system?
I just explained that through Madrid, WIPO charges you CHF 653. WIPO has its own standard fees, and every respective IP office has their own respective fees. For example, New Zealand has a fees of 60 Swiss francs. UAE has a fees of almost 1800 Swiss francs. So every country has a different set of fees. You can just search Madrid fee calculator and you can see the official fees yourself. It's all available online.
Okay. How to confirm which class is suitable? Is there any site which shows in detail of all classes?
You can just simply go to, you can just check NIS classification 12th edition. Your class would be dependent upon your nature of business. For example, class 5 is for pharmaceutical, 30 is for tea and beverages, 28 is for sporting articles. So you can just check it online. NIS classification 12th edition.
Okay, thanks. There's also a question on Vienna codification. What is this and how is this search done?
Vienna codification is used to search for device marks. Like if a device mark has to be searched, that can be done through Vienna codification. And if you are applying for a logo, then the examiners would look into consideration for Vienna classifications while examining your trademark, that it is not similar to any others.
Okay. Okay. Right. The next question is, the US has strict examination standards, including use-based requirements. What should Indian startups keep in mind when designating the US under the Madrid Protocol, especially regarding intent to use and proof of use?
Okay, that's a very relevant question. I think that this has come from someone who is dealing in US. In India, when we file the application, we can file the application on two bases: intent to use or claiming use. Intent to use says that we intend to use our mark. Claiming use is when we are claiming use, that I am using my mark from so and so. But in US, there are also these two options. But the US PTO will not grant you certificate until unless you show use of your mark. So when you're filing the application on claiming use, you need to show use at that point of time. If you're filing it on intent to use, before granting the certificate, you need to file a statement of use, showing use of your mark. If you're not able to show use, you can seek for extension. You show use, you get registration. After registration, every subsequent 5 years, you need to show continuous use of your mark. So that is why people find it a little strict, because other IP offices like India does not have such mechanism wherein they ask you for show continuous use. But yes, US requires use from the applicant after every 5 years.
Right. Wonderful. Thank you. Can an individual IP practitioner eligible to practice as IP facilitator for MSME?
Yes, you need to register.
Okay. Is there any alternative to Amazon brand registry that enables a brand to be registered on Amazon in a way that allows the platform to automatically block infringing listing by other sellers? Next part of the question is, taking enforcement action against each individual ASIN is time consuming and does not prevent future infringements by new or repeated offenders.
Yeah, I mean, Dr. Shivani, thank you for that question. So, I mean, there is no alternative to brand registry, but as I said, brand registry perhaps enable the automated brand protection. So once your brand is registered on brand registry, that also means that the automated brand protection comes into play. That doesn't mean that the circumvention would not happen, but to a great extent, the circumvention would be stopped. There are bad actors who would still sort of, somehow try to circumvent the automated protections. And in those cases, you can use the tools that I mentioned, like report a violation, Project Zero, etc.
Thank you. How to check the list of documents required for filing in international countries? since each country has different requirements?
I would take that up. So if you're filing for national applications, every country, yes, you are right that they have a different filing requirement. But when you're filing through Madrid, those requirements are not as such. You just need to have the power of attorney for India. And few of the countries such as Malaysia, India, New Zealand, UK, and USPTO, Pakistan, they require a declaration from the applicant, a declaration of use. That is the only requirement for the filing from the documents perspective. If you're filing in UAE as a national application, you would require a legalized power of attorney, which in case of Madrid, you would not require. So in Madrid, the documents are very simple.
Okay. All right. Is there a possibility to add already registered mark at Mauritius in Madrid?
Is there any possibility to add already registered mark in
At
Mauritius?
Mauritius, in Madrid, yeah.
Is there a possibility to add already registered mark? If
Not sure if
you have a registration done in Mauritius, so you want to add it to Madrid, right? I think that is the question. Am I getting it right? Like a national application
Yeah, I
converted
mean,
into.
that looks like is the question. Thank you, Sumit. Yeah, thank you for all the questions and answers and your presentation. Very insightful. So
No
very happy
problem.
to have you.
I have to drop for another appointment, but thank you very much for the kind.
Thank you so much, Sumit.
All
Thank
right,
you.
Thank you. Thank you. Bye.
Sorry, Abhishek, please continue. I think I just wanted to thank Sumit before he leaves. So yeah, please.
No problem. I think that yes, there is a provision of renunciation wherein you can add your national applications and convert them into Madrid. But if you, Mr. This question was from Mr.
Munuswamy.
Munuswamy, you can get in touch. You can write down my email address and you can just drop this to me. I will get back to you on this. But yes, through under renunciation, you can get this done.
Okay, great. Anu is asking, please let me know if we can an advocate be registered as TM facilitator so that he can claim professional fee from design office in case of filing TM for startups, as happens in patent case.
Yes.
Okay. Last question. I think we are almost there. Is there a way to check the requirements when filing for national applications? I think this is a continuation of the question previously asked by
National application, you can just simply check on Google. The AI these days is very smart. Just write down documents required for filing trademark application in Egypt, in USA. Everything would be right in front of you. But yes, documents differ when you are filing national applications.
All right. I think that's good. We are there at 4:30 mark. So thanks again, Abhishek. Very insightful, and I think it was really, nice to see how the protection works.
Just one more question: that does SSRN also facilitate patent filing at no cost basis? Facilitate patent? Yes. If you are a startup, we would be happy to assist you at no cost.
Wonderful. Cool.
And if anyone has a query, can I drop in my email address over here?
Yeah,
If
sure.
you guys have any.
Yeah, please. I mean, as long as you're okay, please. All right. So finally, let me thank you again, Abhishek. Again, as I said, very insightful, and I think a lot of practical questions that were answered. So I'm sure the attendees would have found it very useful. Thanks again, and look forward to have another conversation with you.
Thank you, Mr. Cham.
Thanks.
Thank you.
Okay.
Thank you, sir.
All right, Parul, I'll sign off. Thank you.
Thank you, sir.
Please send the summary later.
Sure, sir.